Hello, I'm Adam Corbin, a partner at Michelmores. I'm hosting this series of podcasts released in the run-up to the Cereals Arable event at Thoresby Estate in Nottinghamshire on the 13th and 14th of June this year. These podcasts accompany a series of articles which you can access on our website. We will be at the show with our stand, looking forward to meeting and speaking to friends old and new, hopefully over a cake, gin or ice cream. This time we're going to be speaking about greenwashing, and I'm joined by Ian Connor and David Thompson, who I'm now going to ask to introduce themselves. David.
Thanks, Adam. So I'm David Thompson. I'm another partner at Michelmores. I'm a partner within the commercial team, and I also lead the consumer brands team here at Michelmores, working with an awful lot of food and drink businesses. So delighted to be here talking about what I think is a bit of a hot topic.
Great. Ian.
And I'm Ian Connor. I'm an intellectual property partner. What does that mean in the real world? Well, it means I deal with brands and getting products to market. But in the context of what we're talking about today, it also means that I deal with advertising and how products and services can be promoted.
Okay, so let's get straight to it. Ian, what is greenwashing?
Well, greenwashing doesn't have a precise definition, but in essence, it's where a company or a business tries to promote itself by reference to environmental claims, which may or may not be fully truthful and or accurate. So typically these are claims about sustainability, they're about targets to achieve 2050 net zero targets, or other elements of a product or service which a company wants to make it sound a little bit more environmentally friendly than perhaps it is.
And David, where are these statements generally made?
Well, there's a selection of shop windows for businesses in this space. So certainly in terms of practice, we've come across clients looking for advice around greenwashing claims in connection with TV advertising campaigns, but also in terms of more traditional print literature and copy as well. So it's something which is, I think, really quite all-encompassing, and it really gets back to basics in terms of thinking about how these businesses are projecting themselves and referencing ESG credentials, going into buzzword acronyms there more generally.
So let's imagine that I'm a sausage manufacturer and I want to label up my sausages as being 100% carbon neutral. Who's going to stop me? What's going to stop me from doing that, Ian?
Okay, well, we need to take a bit of a bigger picture on this, and let's talk about advertising generally. And in essence, advertising must be legal, decent, honest and truthful, which means all claims must be clear and unambiguous. They mustn't hide or omit important relevant information. And if you're making a comparison, it must be fair and meaningful. Now, specifically with regard to 100% carbon neutral, we need to understand what that claim means. And one of the real difficulties that any manufacturer will have is whether or not that claim is specific to a particular product and whether or not it relates to just a particular element of the manufacture of that product, or whether it means the full life cycle of that product, or taking it to an even bigger level. And you may have spotted this on a Google search. It says they have been carbon neutral for over a decade. But what does that mean? And so there are a number of people who may interfere with such a claim. There's trading standards if it's on the product packaging. If you put it in an advertising commercial, then you could be dealing with the Advertising Standards Authority. Or if it's a bigger market issue, you might have to deal with the Competition and Markets Authority. Now, specifically when we're talking about 100% carbon neutral, that is a huge claim. And that means that if you want to make that claim, it means that the whole life cycle of that product must be carbon neutral. Now, you might think, okay, well, that's fine because I know where my pigs come from, but sausages are made of grain. So you have to look at where the grain comes from. There's a casing. Where does the casing come from? So you might have got your sausage and you might have looked into the supply chain and you might have worked out that everything that goes into making a sausage is 100% carbon neutral. But then it will be transported from the farm to the factory. The factory will use energy to produce the sausage. And where does that energy come from? Workers go to the factory. How do they get there? The sausages are finally put in some packaging. What type of packaging? Is it plastic? Is it paper? Then finally, it leaves the factory and it gets to a retailer. How does it get to the retailer? How does the retailer store it Are they frozen? And finally, the consumer will pick it up and go, great, 100% carbon neutral. So every bit in that supply chain, if you make that 100% carbon neutral claim, has to be 100% carbon neutral. And so you'll understand that that is, one, really difficult to track all those elements of the supply chain. And two, it probably isn't what the manufacturer meant. What he probably meant was, in producing the actual thing you eat, the sausage you eat, in the agricultural production of that is what I mean by it's carbon neutral. So you have to be very clear that it relates just to the product itself and not the packaging, not the supply chain, in order to make that claim. Otherwise, you could have a problem with any of, as I've just said, trading standards, the Advertising Standards Authority, and or the Competition and Markets Authority.
I was just going to interject there, Ian. So I think that's really interesting, talking about the supply chain piece there, because obviously this is sort of another of those subjects where we sort of see a coalescence of sort of common themes. And obviously there's a more sort of general sort of focus on supply chain traceability and for consumers and businesses to understand their supply chains in a fuller way. And it's something, that we lawyers are seeing in practice in terms of how we're drafting our contracts now. So, for example, obviously we've had considerations around modern slavery and where potentially we're dealing overseas with things like anti-bribery compliance. But actually now I think there's a general sort of move in practice to try and get better visibility more generally. And I think it'll be interesting to see some of the drafting changes that are prompted by the greenwashing codes, etc., and what that means in practice. The other point I was going to tackle, because I think your sort of summary there was fantastic in terms of rolling through those various acronyms there in terms of the ASA, the CMA, and obviously trading standards. There's another acronym to throw in there, I think, as well, which is sort of starting to emerge, which is the FCA as well. And so taking a step back, I think it's interesting for us as lawyers to understand who the sort of the protagonists are here when it comes to trying to tackle greenwashing. And obviously, on the one hand, we've got the consumers, and obviously chaps like the ASA and the CMA and trading standards are very much there to protect consumer interests and generate the right sort of headlines to demonstrate that action is being taken, that spotlight's being shone on these issues. But the other side to think about is actually the investor piece, and that's where the FCA, the Financial Conduct Authority, is starting to sort of generate, I think, some headlines, is actually looking at from an activist investor perspective and understanding that actually these sorts of questions can really affect the bottom line of a business and the appetite of investors to invest and or to continue their investment with particular businesses because of the negative connotations if these businesses are found to be sort of ratted out in terms of some of their greenwashing claims. So I think that's something that we're watching with interest, aren't we, in the coming weeks and months.
Absolutely, you're absolutely right. And a lot of this comes from Europe, despite the fact that the UK is outside the European Union. And there are things like the Sustainable Finance Disclosure Regulation, which imposes on companies over a certain size the obligation to disclose what they're doing in this area. And there's also directive under discussion at the moment within Europe, which applies to greenwashing claims more generally. And so this really is a hot topic across the UK and the EU and the rest of the world. And of course, when we're talking about supply chains, we want our manufacturers to make sure that they are producing their goods so that they're available for export. And that necessarily means that they can't just have an insular view of this. They've got to look as to the wider market and the wider market regulations. So yeah, we do need to look at this. And if we do have, and one bigger piece that we do need to be aware of is if we do have a situation where companies are making claims about their green credentials, we've talked about it in the context of the regulators, but actually we've got to think about what a consumer might think, not only in terms of reputation when a brand is damaged by overstating its green credentials, but the actual reality is that they may have a claim to either return those goods because there's been a misrepresentation, and it might not be today or tomorrow that misrepresentation is found, but it might take the form of a wider market failure, such as the payment protection insurance, whereby a claims company says in a future date, anybody who bought this product, something like the VW and the Dieselgate scandal, if you bought this product during this period, it made these green claims, you're entitled to some compensation. So you've got regulators and you've got consumer claims to think about. So it really is a mixed picture at the moment in terms of what you need to look out for. But what I would say, and the good news is actually you can get this right if you make the claims specific and if you have the substantiation to back up those claims. And so I don't know if that's an area which we should discuss in a little bit more detail now.
Yes, I think it would be good to pick up those points now, and also to consider accreditation and whether you feel that assists businesses in presenting their claims. Ian?
Yeah, absolutely. And this is an actually really hot topic at the moment, because you'll see in agriculture in particular that a lot of people rely on the red tractor. But in actual fact, the red tractor logo is coming under quite a lot of pressure at the moment. And there is an organisation, a pressure group called River Action, which has just launched an ASA complaint, actually more directed at the dairy industry than the cereals industry, but still it's relevant, basically saying that when that was looked at, farms that operated pursuant to the Red Tractors scheme were not actually living up to the environmental standards promoted by the scheme. And in essence, what we're expecting companies to be able to do is to have at their fingertips current, and it is important that any information which supports an environmental claim is up to date, saying precisely what they're doing. And if we took carbon neutral as an example, what they're doing in terms of using renewable energy, what they're doing in terms of reducing carbon emissions generally in respect of how for example, the farm machinery is powered and other elements. And provided that the claim is limited, then they can make that. And so one really helpful advice that we give is, rather than making a claim absolute that says, we are carbon neutral, you can say we have reduced our carbon emissions by a percentage. And often you can do that by reference to the fact that, for example, some of our power producers offer electricity on a green tariff, and they will say that therefore is something that you can rely on to substantiate your claims. It might be that there's been a solar scheme put in place which is providing 50% of the power for a factory, and so you can say you are reducing your emissions by whatever that 50% reduction in traditional power sources provides. So we can make relative claims and we can substantiate them, because that'll be far easier than trying to say absolutely we are 100% carbon neutral.
It's a real challenge, though, isn't it, to demonstrate that your green offering and your ESG offering is in some way better or of a higher quality than that offered by the competition. And I wondered if either of you had had to tackle that in practice.
Certainly, I'm happy, Adam, to talk to one particular example. And I think it's quite interesting, actually, when you sort of put this into the real world, because obviously lawyers spend quite a lot of time talking about sort of themes in the abstract. But obviously what's most important to our listeners is really how this is applied. And I think it must be remembered, obviously, that what all of these sort of enforcement authorities are trying to do, and the codes and various other structures that are being put in place are trying to do, is basically make sure that people can tell their story properly and that consumers can understand it. So this isn't trying to trip up those businesses that really do have a great green sort of story to tell. But it was fascinating for me in the last 12 months to work with a client who is a B Corp and who has a fantastic story to tell. And yet perhaps they'd been a little bit, I suppose, remiss in terms of how they had audited and structured their approach to logging their green claims. And so we worked with them to lend some structure there. And I must confess that involves some very big spreadsheets. But we basically went through with them systematically, and there was an awful lot the client could do here, which I think is important. This isn't just the lawyers sort of in a feeding frenzy of lawyers. A lot of this is just sort of gently sort of signposting to a business how they can help themselves. But even with the business like the one we were dealing with, they catalogued the number of potentially relevant and sort of captured green claims that they were making across their wider promotional literature and advertising literature. And they catalogued, I think, over 120 claims or statements that were potentially relevant and might be captured by the code and which needed to be substantiated. And we then worked through them and did the sort of the traditional lawyer thing with a red, amber, green type output to try and signpost precisely where we had sort of claims that were good to go, that we could properly substantiate and where we could trace back to sources, etc. Those that were slightly more dicey, and to be honest, there were some there which were absolute no-nos. And it was a fascinating, I think, exercise for the client as well, because they perhaps hadn't recognised, notwithstanding the fantastic story they had to tell, that they'd probably been telling that story a little bit too long now, and they hadn't actually checked back to, in part, understand the changing marketplace and the fact that some of the data that they might have been relying on was now, frankly, woefully out of date. But actually, sometimes when they checked back in, they found the position had improved, so they had a better story to tell. So I think, to my mind, it was a really interesting exercise in showing that, a client who has a good story to tell might still find themselves in a bit of a pickle unless they actually take the time to look into that granular detail. But that if they do engage, it will give them, I think, the confidence to really kind of move it forward and invest in their advertising. I think it's particularly important for clients where they're thinking about sort of a renewed or refreshed advertising spend, perhaps a commitment to TV or radio advertising, something like that, where they really do want to do their homework. Because the fact of the matter is that, we've got some fairly active consumers out there, and as Ian's saying, we've got, unfortunately, some circling litigation lawyers potentially in the medium to long term who are going to be looking for those businesses who might be tripping themselves up. And so sorry, and I was just going to say, I think it's just important to make sure businesses do their groundwork, their homework, to make sure they're comfortable going forward.
And it's on precisely that point that my recent experience comes in. A retailer client of mine advertised a vegetarian burger and basically made a claim that burger was better for the environment than a meat-based burger. And they put forward as their substantiation what is accepted scientific evidence, which is a plant-based diet is generally better for the environment than a meat-based diet. Now, the problem with that was the fact that that wasn't the comparison that they were making. They were making a comparison about that particular plant-based burger against their meat burger. And in those circumstances, what you've actually got to do, you've got to look at the environmental impact of both those products and compare them. And that is the substantiation you need for that particular product, because that's the product you're advertising. If you were making a general claim that a plant-based diet is better environment than a meat-based diet, without reference to a specific product, you can make that based on the general scientific knowledge, but not if it relates to a specific product. And that's what the Advertising Standards Authority codes tell us. So they're actually called the broadcast code and the non-broadcast code. And what it says is that the basis of environmental claims must be clear, and it should be noted that claims can mislead if they omit significant information. There's also a real consumer focus in that those claims must be clear for consumers to understand. They're not technical scientific claims, and so they really must be written in a language which a consumer can understand. I've already touched upon this earlier and talked about the difference between an absolute claim and a comparative claim. And generally, an absolute claim must be substantiated to a really high level, whereas comparative claims, greener or friendlier, and in the plant-based burger that I was talking about, you could have said this is greener than the meat-based burger, provided you'd got the substantiation for those specific products. And again, something I've already touched upon, which is this idea that you've got to be clear whether you're talking about the full life cycle of the advertised product or just a specific part of it. You might be using less packaging, or you might have switched from a plastic-based packaging into a starch-based plastic packaging, which is capable of biodegrading. And so look to a specific claim of part of the product rather than making a whole life cycle claim. And again, with regard to the comment I was making earlier about what scientific evidence you can rely on, you can rely on it to make a general statement about a type of diet, but you've got to be careful if there are two opposing views, and if something that you regarded as the accepted scientific opinion is actually not universally held, then you will probably not be able to rely on that for your substantiation. And finally, I would say that if it has always been accepted that doing something doesn't have an adverse effect on the environment, then you can't try and make a virtue out of that. And so it's one of those things that sometimes people will say, we deliver to a high standard or we deliver to a standard, but it might be that that's a minimum standard set by the government and it's set in such a way as not to have an environmental impact. So you can't use that and try and make a virtue out of it. So they're the specific things for the environmental claims, but of course they sit in the context of a wider framework that advertising should not be generally misleading.
So it seems really that there's often a way through, and as with many things that lawyers are connected with, the devil's in the detail. But it must be really difficult, David, to audit your supply chain. If you're at the top of the supply chain and you're effectively the retailer, it must be really difficult to keep control of the goods that your suppliers are supplying you. And I've just wondered what tools are available to keep suppliers honest, as it were.
Yeah, I think that's getting into the practicalities is very important here, Adam, because I'm conscious that we lawyers are past masters at sort of pontificating and sort of doom mongering. But obviously, what our listeners really want to understand is what do we need to do now, and how can we tackle this? Because it's obviously an issue that needs to be addressed, prioritised. What we are seeing now is obviously you talk about sort of the top of that supply chain, the major mults. Obviously, their terms and conditions are generally fairly draconian and fairly non-negotiable in these sorts of circumstances. We're starting to see that they are picking up on these issues and looking to, I think, generally enhance their audit rights, which were already fairly all-encompassing. And I think it'll be interesting to see how that sort of percolates down through the supply chain. Certainly where we're working with clients who are a little bit sort of further down the supply chain, we are trying to ensure that they do have those general audit rights, and if necessary, also signposting the fact that that may include looking at some of these claims, these greenwashing issues. I mean, I think it comes back to my earlier point as well, really, that a lot of this is just about being prepared. Generally speaking, we lawyers don't like unknowns. We like trying to flush issues out and get to grips with them so that we don't have any nasty surprises and our clients don't have any nasty surprises down the line. And I think it's just remembering here who we are trying to talk to as an audience, where we are working with businesses. And so we've also got the consumer piece. And I think there, where we're looking to catalogue claims, it's just a question of trying to keep those documents live. So I talked about these sort of spreadsheet or sort of quite structured approaches, and I think that's absolutely the right way to go. And then I think it's a question of those being live documents where you do have as line items broken down, individual statements, claims that are being made by the business, and then looking to refresh them, update them, and check in on them on a fairly regular basis just to make sure they can still be substantiated. And I think that will also serve a sort of a higher purpose almost, and one that might be more pertinent quite often in practice, which is actually also being able to substantiate to investors, whether those institutional investors or individual investors, actually what the business is doing. So rather than having to scrabble around when you're asked potentially slightly awkward questions about how you've actually substantiated your claims, you can just pull out your lovely little spreadsheet and demonstrate that you're on the front foot. And I think that can save embarrassment, and I think also foster confidence in management that this is something that you're taking seriously in practice.
Just to add to that, I think that businesses want to do the right thing, and especially, they do have to rely on their suppliers. But I was once advising a high-end pet food manufacturer that made a big play of its credentials, not just in respect of the G in ESG, but across all ESG. And one of the problems when we looked into their supply chain was if, it's bizarre because it was pet food, but if they looked into some of the herbs and spices that they wanted to add into some of their products, it became really, really difficult when you're looking at some herbs and spices which come from the Far East and subcontinent, because you get into definitely the S and the G in terms of things like use of child labour and wider environmental impact in terms of things like deforestation. So it can become very difficult very quickly, even though at the heart of a company it really does want to and is trying to do the right thing. But that supply chain runs really, really deep, and so businesses do need to be very careful when they add an ingredient or change an ingredient to make sure that they're not unintentionally upsetting what are otherwise very strong and positive claims.
So that's great that you've raised the S and the G of ESG. So that's social and governance. Is it the same? Do you encounter the same issues for social and governance matters with suppliers and retailers making claims?
Well, it's a broad point, really, which is under UK legislation scheme generally, there are certain obligations. And if you took, for example, bribery and corruption, an offence that takes place in a supply chain is an offence that could be punished in the United Kingdom. And so what you need to do if you're doing this well is to make sure that you have a documented process which makes sure that your suppliers have signed up that they don't engage in such practices anywhere. And it is a question of substantiation, and it's making sure that that is documented. And again, there is a counsel perfection here that obviously as a lawyer we are alive to, and we know that businesses do find it hard. But what we would say is that you can mitigate your liability by at least being alive to the issues. And as long as you've got a process that's asked the questions and asked for the guarantees, and that's not just a tick box exercise, then that should mitigate any liability that you have. But again, to repeat David's point, it's really difficult and it's not easy, and we don't want to be the lawyers sat in our ivory towers saying, oh, you must, when we realise the practical difficulties of doing it on the ground.
It must be much more difficult, though, with social good to demonstrate that the promise or the assurance of a quality social good being provided has or hasn't been met. It must be much more subjective.
Well, it is. And that's why, we don't want to sit here pontificating. But I think, as long as businesses are alive to the broader ESG agenda and how it can impact, then we believe that we can put clients on a good footing to do the right thing, and actually not just for the purposes of avoiding liability, but actually to deliver the social good that the ESG agenda is trying to deliver. Because ultimately, this is not just about complying with the law. This should be about generating products that are less impactful on the environment and less impactful on the world as a whole.
I was just going to add to that, Ian. I think what's really important here is trying to make sure that businesses are as much on the front foot as they can be. And I think it's really important to remember, actually, this is very much an emerging sort of area for regulators and for lawmakers generally. I think it's obviously worth just sort of reminding ourselves about the timescales here, that actually the CMA only really sort of started to engage with this in the last 3 years or so, in terms of actually making substantive changes to the way that we're managing risk here. And so it's been interesting actually just looking at some of the headlines in this sort of industry news in recent weeks and months. And I'm conscious, for example, at EU level, they're sort of starting to turn their spotlight onto commodity traders, for example, and recognising some of the structural impacts that they can have on the marketplace. So, for example, chaps like Cargill thinking about some of the impacts that soy trading may have in terms of sort of global deforestation. And so I think part of this really is us trying to encourage businesses out there to engage, recognising that there are still sort of areas here which are sort of in flux, which are still waiting to settle down, but we have got some navigation points already. And I think that what both investors and the consumers all want to see is that businesses are trying to engage and, as you say, are able to evidence where they can that they are doing the right thing.
And just to develop that future regulation piece, the sustainability financial disclosure regime, which is currently an EU thing, is going to come into the UK. As with all disclosure regimes, they usually start with businesses at the bigger end of the scale, but as soon as they are implemented for big businesses, then SMEs start to become impacted. David's already touched upon what's happening with the CMA and how they've just got involved. They're currently investigating the use of cotton by Asda, Boohoo and ASOS in clothes as a market failure potentially, and we will see ever increasing regulation as the environmental agenda gets more embedded in each and every law. So that regulatory piece is going to increase, and I think that it's a real watch this space. But I think, as hopefully we've been able to demonstrate, we can see a way through this for you. And we'd be delighted to pick up on any of these specific points.
I was just going to pick up as well, because I'm conscious that we lawyers as a gang are fantastic when it comes to catastrophizing and really scaremongering left, right, and centre. But I think what's important here is to also try to get back to real world risk and just think about why this is important. And for me, in terms of practice, the key, I think, here is actually potentially at the moment, at least, around the court of public opinion. And I think it's all very well that these regulators do have the ability to sanction, and we can talk about that detail. I mean, some of it's quite dry, to be honest, but I think what we're really seeing playing out is actually that there is some tremendous consumer engagement out there. And this is a live talking point. And you can see it from the various sort of social media networks that when a business is sort of ratted out on this front with the greenwashing claims, there tends to be quite a consumer pile on. And so I think actually when it comes to real world risk, notwithstanding some of those sort of slightly more esoteric sanctions the regulators can play to, I think part of it is that court of public opinion. And I think that is supported by the ASA, for example, who have been quite vocal in terms of compiling what I would describe as naughty lists of some of the businesses that really are not playing ball at the moment. And I won't go back through those names to name and shame now, but I think that piece about public opinion is very important here and just trying to manage reputation in the marketplace.
Great. Thank you both ever so much for your time. It's been really, really interesting and great to have both of your perspectives. So just one final question each, which is what you're looking forward to most about coming to Serials this year. David?
For me, it's talking to businesses. And I know that can sound a little bit trite, but actually we lawyers are actually quite social beasts. We like the law and the black letter stuff, but actually it's the applied piece that really gets the old creative juices going. So really looking forward to actually meeting people on the ground, talking about, what they're seeing in the marketplace and getting to understand where they might benefit from our legal input.
Great. Ian?
As an IP lawyer, I'm always interested in understanding what tech and innovation is being used, and therefore just speaking to people who are actually on the ground, seeing how their businesses are developing and how they're using ever increasingly sophisticated technology and how they are innovating, not just with regard to efficiency, but hopefully to see how they're innovating to deliver some positive environmental change.
Brilliant. Well, thank you both again very much, and we'll look forward to seeing you there.